of Bill C-14, an act to amend the Criminal Code, the Youth Criminal Justice Act, and the National Defense Act, bail and sentencing. Today's meeting is taking place in hybrid format. Pursuant to the standing orders, members are attending in person in the room and remotely using Zoom. There's nobody on Zoom, is there? There's nobody on Zoom? No, okay. All right. I would like to confirm the sound test. There's nobody on Zoom, so I will skip that part. I would like to make a few comments before we start for the benefit of witnesses. Members, please wait till I recognize you by name before speaking. For those participating by video conference, that doesn't apply. Zoom doesn't apply. This is quite easy today. All right. I'll skip right to. So for now, I want to thank our witnesses appearing today. In the first hour, we have the Honourable Sean Fraser, Minister of Justice and Attorney General of Canada. Thank you for attending, Minister. With the Minister, I would like to welcome our witnesses for today in the first hour from the Department of Justice, Owen Ripley, Senior Assistant Deputy Minister, Policy Sector, Matthew Taylor, Senior General Counsel and Director General, Criminal Law Policy Section, and Chelsea Moore, Senior Counsel, Criminal Law Policy Section. Minister, again, welcome, and I will turn the floor over to you, sir, for your opening remarks.
And how much time do I have, Mr. Chair?
10 minutes.
Okay.
10 minutes.
Thank you so much. I want to wish everyone a Happy New Year. I'll endeavor to take less than the time allotted to allow more time for questions, knowing that I've got a hard stop at 5:30 and I don't want to avoid the questions you may have or be seen to avoid the questions that you may have. Let me just start out by saying that crime and criminal justice reform is obviously a pressing priority for Canadians who've experienced certain challenges in their communities in different parts of the country that demand the attention of the Government of Canada. The fact that it's a priority for Canadians has made it a priority for the Government of Canada, which is why we've conducted ourselves with commitment to the cause from the moment this government has taken office, advancing new laws as part of a broader strategy to improve public safety. Before I get into the specifics on the Bail and Sentencing Reform Act, which we're here to discuss today, I think it's helpful to situate it in the context of the broader public safety strategy. The first pillar of this strategy is, in fact, to adopt stronger criminal laws to help promote safety in our communities. That includes, of course, the Combating Hate Act, the Bail and Sentencing Reform Act, and apropos of the timing, the Protecting Victims Act, which is being debated in the House of Commons this week. In addition to adopting significant reforms to Canada's criminal laws, we're also making additional investments in the front line to help promote safety in our communities. This includes major investments in the RCMP with 1,000 new officers, major investments in the border with 1,000 new CBSA officers, but it also includes support for frontline organizations, particularly those that support survivors of violence and victims of crime. In addition to these supports on the front line, we are looking at making upstream investments that will have a positive impact on violent crime in the long term. This includes investments in mental health and addictions. It includes investments in affordable housing and supportive housing. It includes programs that target at-risk youth and infrastructure that helps build stronger communities and healthier people, which will promote public safety in the long term. Il est essentiel pour adresser les priorités des Canadiens qui considèrent crime.
It's essential for the government to respond to this important issue for our communities. This strategy includes three things, which I mentioned in English. But when we have the opportunity to do so, crime and criminal justice reforms, we also have an opportunity to make changes to protect our community.
Today is on what I would suggest is perhaps the biggest political priority for Canadians when it comes to criminal justice reform, which is addressing the challenges in bail and sentencing that Canadians are calling for. And indeed, the measures that we've included in this bill are gaining the support of law enforcement organizations, police, those who work in the courts, provincial governments of different parties from different regions, municipalities and other actors within the justice system. Though the long-term solutions to public safety can be very nuanced, this bill has at its core two main themes, bail and sentencing. When it comes to bail, there's a number of measures I want to draw your attention to. First is changing the way that we deal with the principle of restraint by directing courts to ensure that they're considering the public safety imperative and communicating that release is not mandatory, but in fact that if public safety cannot be managed, there are grounds to detain a person who appears before the court at a bail hearing. We also are urging the court to consider new factors, including not only the seriousness of a charge that a person may be facing, but also the number of charges that they have faced in history to ensure we're dealing with violent crime, but also very high volume offenders who are changing the dynamic of downtown cores across the country. We also seek to impose new conditions on bail. They follow largely the offence to which they're tied. When it comes to organized crime, having non-communication orders seems like a good idea. When it comes to people who have been facing many charges for home invasion or auto theft, prohibiting the possession of break-in devices is the kind of thing that we're talking about. There are other examples, but they all naturally follow the logic tied to the crimes to which they're attached. In addition to these conditions, a major feature of the bail reforms, informed again by law enforcement and actors in the criminal justice system, is to implement a series of reverse onuses, insisting that in all instances it should not just be the Crown who bears the onus of demonstrating that a person should be detained, but for certain crimes where there is potentially a higher risk of recidivism or in some instances ties to organized crime, there's an opportunity to flip the script, so to speak, and insist that the person who is facing these charges demonstrate why they ought to be released by putting forward credible information as to why the public safety imperative can be managed and why the public confidence in the justice system should remain. In addition to these important reforms, when it comes to bail, there are certain changes we're making to the sentencing framework that exists in this country. This includes new aggravating factors that touch on repeat violent offenders, that touches on crimes committed against our first responders, when it comes to organized retail crime, and when it comes to crimes that, though they may fall in the class of crimes that are theft under $5,000 often, have outsized impact on our essential infrastructure. We're also looking at adopting consecutive sentences for a range of different crimes, including, for example, extortion and arson, which I've seen in the news in Winnipeg as recently as this morning being an issue that needs to be addressed with certain arrests that have been made. This would also apply to people who are facing charges for both home invasion and auto theft, which has obviously been a pressing priority. I'll note that the crime rate has significantly dropped in recent years when it comes to auto theft in particular, but there is more work that we need to do to continue this positive trend. We'll also be prioritizing the principles of denunciation and deterrence when it comes to home invasion, auto theft, and organized crime, and ensuring that conditional sentencing orders will not be applicable for sexual offences, including sexual offences against children. Quand nous avons d'opportunités pour renforcer des règles.
When we have an opportunity to strengthen rules in the criminal justice system, it's essential to consult with those who have experience.
In closed doors on Parliament Hill. They are the result of extensive engagement with people who live and breathe the justice system, people who are charged with the responsibility of keeping our community safe and administering our systems. I've endeavoured to be under the clock that I have been allowed, Mr. Chair. You've been very gracious to give me 10 minutes. By my count, I've got 7. Let's donate the additional 3 minutes to the questioners. Thank you.
Thank you, Minister. Your clock is the same as mine, so we appreciate the extra time. All right, we'll start off the 6-minute round with Mr. Lawton.
Here we go.
Thank you very much, Chair. And Minister, thank you very much for being with us today. You said in your remarks there that bail is the most pressing criminal justice priority for Canadians. Why was Bill C-14 not your first criminal justice bill in this Parliament?
Thank you very much, Mr. Lawton. The answer is fairly simple. We wanted to ensure that we had the opportunity to engage extensively with the people that we had faith would give us the advice that we needed. As I mentioned, this wasn't a matter of sitting down for a meeting in a boardroom on the Hill. I had the opportunity over the course of the summer and into the fall to engage with police leadership, with provincial governments, with municipalities, with advocates for change across a range of different issues. And I didn't want to present a bill before I had faith that the advice and expertise of the people who would strengthen it could actually be captured and included in the bill.
This committee's first priority in this Parliament was a study on bail. We heard testimony from witnesses, including municipal leaders, a range of police chiefs, police association leaders, and all of them said that liberal justice laws in the last 10 years have made things markedly worse. I'll quote Police Chief Mark Roskamp from St. Thomas, Ontario, in my riding. He says, "I believe C-75 has created less safe communities. That is my opinion based on a near 30-year career in policing." Mr. Chang asked a question to Brian Sauvé of the National Police Federation. From the RCMP's perspective, how has Bill C-48 improved the safety of victims and the safety of officers on the front line? Mr. Sauvé said, "I don't think they have." So why are law enforcement to believe that C-14 will be any different when we've had these promises in the past that have not made things safer for communities?
Well, look, I think the key difference is the process of engagement, including some of the names that you've mentioned. Brian Sauvé, for example, was one of my first phone calls. That was in the context of the Strong Borders Act, which he still continued to advocate Parliament to adopt. But the response from law enforcement, I think, speaks volumes. They see themselves in this bill because their advice led to the creation of the proposals that are included in the bill. So I don't want to debate the different laws that were adopted over the course of Canada's distant or recent history. We have an opportunity to change the path going forward. By listening to law enforcement, I have faith that we have put together a bill that's going to improve their experience of policing in our communities and, importantly, improve public safety outcomes for Canadians.
The reason Chief Roskamp and numerous other police have specifically singled out Bill C-75 is largely because of the principle of restraint. This is a section of the criminal code that says judges should give primary consideration to release the accused at the earliest reasonable opportunity and on the least onerous conditions. Bill C-14 puts a clarification there, which says, for greater certainty, Section 493.1 does not require the accused to be released. A clarification is not a fundamental change. So are you of the view that the principle of restraint has been misinterpreted by judges and a clarification is simply all that's required to address this issue that law enforcement has been raising?
I take a slightly different view, and if you'll allow me maybe 30 seconds, I'll try to give you the nuanced answer. So first, Bill C-75 has other measures that I actually believe are very important, making it harder for people who've been charged with intimate partner violence offenses, for example, to be released on bail. We should protect that. One thing that's essential to understand is simply doing away with the language that's in the code today wouldn't get rid of the principle of restraint at law, because that actually was brought into Canadian law through the Supreme Court of Canada's decisions, which make it part of the body of common law, which has application today. By actually putting in not just clarifying language, but by directing the courts to deal with that principle differently, we can have a more profound impact than would be the case if we simply removed it. Specifically, it doesn't only clarify that it doesn't mandate release, it demands that courts consider the public safety imperative and communicates with no equivocation that if the public safety imperative cannot be managed, there are grounds to detain the person who appears before the court, and that's an important change we should make.
So that was closer to 60 seconds, but I do want to give you an opportunity to explain this. But is your view that judges have been interpreting the principle of restraint incorrectly? Because by clarifying it, it seems to be that you're effectively saying that all of these police officers who have said the principle of restraint has made it easier to get bail, that they're all wrong when they tie it to that section of the law.
Well, I think the principle of restraint pre-existed the changes that were made to bring it into the code through the history of decisions that now form part of the body of law that comes from our courts in Canada. I think we need to communicate for two reasons. One, to give direction to the court as to how we wish it should be interpreted, but also to give faith to Canadians that a very real and pressing priority, based on their lived experience, has the full attention of the government, and we can't have any equivocation. I don't want to criticize, certainly, the court or judges en masse or individually, but I do think that this direction is timely and important. Criminals
can vouch for criminals as sureties under our current system, and this is an ongoing problem we've seen. Police have raised it as an issue. Bill C-14 does not address sureties. if this was something that you wanted to get right, why have you left out that key piece that some of the very people you've consulted with have, even before this committee, said we need to deal with?
Look, we had an opportunity to engage on the issues that people raised with me as priorities, with our department, with my political team as well. And the endorsements we've seen from law enforcement have communicated to me that we've done a pretty good job of incorporating their feedback to the extent that the work that this committee has conducted should inform proposed amendments. Know that so long as they don't oppose the spirit of the bill, if they are going to have a positive public safety outcome and don't create unwanted collateral consequences, I don't want to be dogmatic about these things. I just want communities to be safer.
Would you be open to amendments on sureties?
Thank you, Mr. Lawton. That's all your time.
But we can discuss subsequently.
Mr. Chang for 6 minutes.
Sir, welcome to the Justice Committee. Thank you for being here and for your continued engagement with the committee. We appreciate the work you and your officials are doing to protect Canadians and to make sure that our justice system remains fair and responsive to the challenges that Canadians are facing every day. My very first question to you is that since introducing Bill C-14, what kind of reaction or feedback have you heard from the provinces, territories, police leaders, and frontline justice partners?
Look, I'll answer your question slightly differently than you've asked it, only because their reaction started to come in before we released C-14, and that's because of the way that we engaged. There was a pleasant surprise, frankly, in some instances, with the approach that we've taken, because we so sincerely wanted provincial governments to inform the final version of the bill. I think to myself about the engagements that I've had with my counterpart, Conservative counterpart in Ontario, Attorney General Doug Downey. Many of the ideas, including how we're going to look at a new process for reverse onuses, came from conversations I had with Attorney General Downey. I think about my engagements with Matt Weep in Manitoba and the advocacy that he put towards, including specific provisions that would deal with attacks against first responders. I think about Nikki Sharma in response to the horrific murder of Bailey McCourt, insisting that we make changes about refusing bail when someone's been convicted pre-sentencing. Their reaction didn't just follow. It actually was part of the process because they appreciated that engagement. But when we included that feedback in the version of the bill that we presented in the House of Commons, they didn't just say nice things in public. In some instances, they asked to be present at press conferences to feature some of the elements that they had advocated to be included in the bill. So to answer your question summarily, it's been a uniquely positive reaction.
Thank you. And Bill C-14 focuses on repeat and violent offending. Why was it important to be targeted and precise?
Well, look, there's real challenges that we see as provinces in particular who have a constitutional responsibility to administer the justice system are facing real challenges when it comes to volume. We're looking at trying to ensure we change the system by putting our focus on people who pose danger to our communities, who have a history of committing violent offences and violent offences repeatedly, people who are tied to organized crime, who we know can achieve a level of scale that is far greater than any single individual. So we really wanted to address the measures that we thought would have the most profound impact on public safety and that would ensure the precious resources that provincial governments put into the justice system have the greatest impact.
Thank you. And stakeholders have long pointed to the challenge of uneven bail decision-making process across Canada. How does Bill C-14 help promote greater consistency in the application of bail principles nationwide? And what mechanism will the government rely on to ensure Parliament's intent is reflected on those provisions are applied in practice?
So I think things like the exchange that I had with Mr. Lawton on providing not only clarifying language but direction on how certain principles ought to be applied is a healthy start. But I do think we would be kidding ourselves if we said any one particular law will in of itself solve all of these problems. We need to complement the measures that we put into the criminal code with collaboration with provincial counterparts to ensure that as rules change, there's training resources put in place, that we actually have the capacity for people to meet the demands on the system, which are under pressure with the volume that they're facing right now. But through continued engagement, bringing together the different provinces and territories with the federal government, making sure that we're continually engaging not just with lawyers and judges and court administrators, but with law enforcement, municipalities and provincial governments, we can bring everyone on the same page and pull in the direction one direction more effectively.
Thanks. Minister, the BC Attorney General Nikki Sharma has stated that what happened to Bailey McCourt should never happen again. and that she's hopeful that these bail reforms will prevent another tragedy like hers. Can you please explain how Bill C-14 will better protect victims of intimate partner violence before situation escalate to that point?
Yeah. Look, this was a tragedy and sadly a preventable tragedy. And I've had the opportunity to meet family members of Bailey McCourts. And this is a cross-partisan issue of concern. I should point not only to Attorney General Sharma's feedback, which I mentioned. She's uniquely responsible for us making the decision to include reforms around refusing bail post-sentence or post-conviction pre-sentence, as well as changes to the law that would create a reverse onus for cases of assault involving choking or strangulation. Frank Caputo, our colleague with the Conservative Party, has been doing really good work and engaged routinely with me in a collaborative way to find a path forward so we could support a private member's bill with potential amendments that would achieve a greater degree of protection for crimes in an intimate partner violence context. We've seen our colleague Steve Fuhr, who was actually the first person to raise the case of Bailey McCourt with me as a pressing priority for the community that he calls home, with advocacy for some of similar measures touching on those that are in Frank's bill and that AG Sharma has put forward. So that level of engagement has led us to include certain measures not only in Bill C-14, but also in a private member's bill that I expect will see some amendments and hopefully attract support of all parties in the committee, as it did in the House of Commons.
Thank you.
Okay, thank you. Mr. Fortin, for 6 minutes.
Thank you, Chair. Minister, welcome to the committee. Ladies and gentlemen, thank you. The tabling of C-14 has given rise to positive responses from most police associations, and it's also raised a number of questions and criticisms from, including from organizations defending civil liberties. I'd like to hear you on the matter of who was consulted when you were drafting the bill. What groups were consulted?
Look, I won't be able in a few minutes or from memory to be able to give you a complete list. If it's something you'd like to discuss offline afterwards.
Non, mais juste de mémoire, comme ça.
Just
Moi-en quelques-uns, peut-être.
OK, j'ai des conversations.
I had exchanges with police associations, with the provinces and territories, with municipalities, sometimes with national organizations, but I also had exchanges with organizations who
the quality of my French, but there was a number of different groups that I had the opportunity to meet with, and I'd be happy to provide a list of engagements if that's useful.
Avez-vous consulté le barreau du Québec, Monsieur le Ministre?
Did you consult the Quebec Bar Association?
Avec le ministère. I'm trying to go from memory. There was many dozens of groups that I had.
Okay.
I'm trying to remember which.
Et le barreau canadien?
And the Canadian Bar Association? Yes, I had conversations with the ULCC, which is a conference that takes place every year, but consultations to hear the opinion of leaders of the bar associations. It's difficult. When I have meetings, it's not always just a meeting with one specific organization. Sometimes organizations participate in conversations that take place in other contexts, in other frameworks.
Go from memory with roundtables with 10 or 20 groups.
Merci, Monsieur le Ministre.
Thank you, Minister. Minister, currently, experts who have provided witness, who have been witnesses here, witness testimony here, say that more than 70% of inmates in provincial prisons are there preventively. That is, they haven't been declared guilty. They're just waiting for a trial. And this is not a tiny number, almost 3/4 of inmates. Are you aware of the statistic? And what do you think about it? Yes, this is an important issue. It's a problem in the justice system. It's not just a problem in Quebec. My view is that the way to tackle this problem is to set out rules that seek to uphold public safety and make greater investments in the system. But aren't there already too many prisoners who haven't even been convicted. Shouldn't prisons be to detain, to hold people who have been convicted of a crime?
No, you're thinking of jail.
We agree.
There's a difference
But
between
I'm going to say
jail
this
and
in English
prison,
because it's
ma'am.
difficult to say this in French.
Framework to promote public safety. The answer to our process challenges are not to weaken the criminal laws that we have, but to have the levels of government who are responsible for different aspects of the system to make the investments necessary to keep up with the demands. The changes that we're making in this law uniquely come from requests that have arrived from provincial governments who are being excellent partners, who want to make the investments necessary. Sometimes that will include resources of the federal government with additional appointments to the superior courts. Most often that includes investments from the provincial system. But I just wouldn't accept that the right solution is to weaken the law in order to solve that issue.
Merci. Je m'excuse de vous bousculer, Monsieur le Ministre, mais vous savez que
I'm sorry to cut you off, Minister, but we don't have much time. Experts also tell us that they don't have any data, any statistics on the number of repeat offenders, on rehabilitations. Are there people who are held preventively, will commit a repeat offense before being convicted? The statistics are very vague or non-existent, and a number of experts have pointed this out. Are there those in your department who seek to establish a database to collect this information and to better work with the prison system?
Je pense que c'est une bonne idée.
I think it's a good idea to collaborate with the system in each province. You're quite right. There are problems given that this data doesn't exist, but in some municipalities they are skilled at understanding this information. There is data in different provinces. I think it's a good opportunity for the committee to make a recommendation to enhance collaboration between provinces and with the federal government.
Both in terms of what we collect, uniformity, best practices would be a huge opportunity to improve the quality of the decisions that we can
il me
take.
reste quelques secondes, mais est-ce que vous avez des
I just have a few seconds, but do you have any ideas of investments that could be made, federal transfers to province to improve rehabilitation of inmates, to limit repeat offenses?
In the seconds that I think we have remaining, I think maybe we should have a deeper conversation about this. Mr. Chair, I think are we out of time?
You have 4 seconds.
Yeah, okay, let's discuss offline perhaps to improve the situation, but I think there's areas for
Thank
collaboration.
you, but I don't believe it's an answer to my question.
Well, we'll have to wait until we have that opportunity.
Mr. Fortin,
Merci, Raya.
the good news is you'll get another opportunity in just a few minutes. Mr. Barber, we'll start the 5-minute round with you.
Thank you, Chair. Welcome, Attorney General. One of the big failures of Liberal Bill C-75 is that it created a diversionary regime for offenses involving failures to comply with court orders. So offenses such as failure to appear, breach of undertaking, or even breach of bail conditions may often go unpunished. Basically, C-75 allows Crowns to divert or to remove those offenses off the docket. This has been a spectacular failure. Why is this not addressed in Bill C-14?
So, look, I think just from a philosophical point of view, there are dangerous people that need to be incarcerated because they pose a public safety risk. The circumstances surrounding an administrative charge can vary significantly. In some instances, particularly when you're dealing with low-income Canadians, there may be somebody who missed a court date because they had no access to childcare, there's not public transportation, and they can't afford a car. I don't want somebody in those circumstances to necessarily be incarcerated when they don't pose a public safety threat. Now, if there are people who are violent repeat offenders who are also acting in contempt of court, there's actually increased penalties included in Bill C-14, which is a better way, in my view, to deal with that. So making sure we don't use too blunt an instrument to incarcerate people who pose no public safety threat, but through life circumstances of which they're not in control of, find themselves before the court in these kinds of proceedings is an important thing that we need to allow courts to deal with.
Attorney General, our committee heard from Mr. and Mrs. Best, the parents of Kelly Verry, 28 years old, who was killed in a car crash last January by a drunk driver. At the time of this tragic incident, there was a warrant for his arrest for breaching bail conditions. In fact, that was not the first but the second time that he was wanted for breach of bail. He had already breached before. The mom, Michelle Best, said to us that Kelly's death was completely avoidable. Let's talk about that as a philosophical issue. What would you say to Kelly's parents about why Bill C-14 does not go far enough to punish those who breach bail conditions?
Look, I would say, first of all, that there is no tragedy that can compare to someone losing their child. There is no answer that you can give in the criminal code that will bring someone back to life, and it is a pain that too many people in this country have felt personally and know deeply. My understanding of that case is that the person was actually released on Crown consent, so I don't understand that that was a shortcoming with these specific rules, but perhaps with how things played out in that particular instance. If there are dangerous people who are also breaching bail conditions, that is absolutely something that the court should be considering. Making sure that we're dealing with people who pose that public safety risk is precisely the kind of thing that I believe Bill C-14 will do. It's not going to bring back someone's loved ones, but it does have the potential to prevent further loss of life in the future.
Attorney General, I'm especially concerned that there may be no real consequence for those who breach bail conditions. If someone who breaches bail and commits a violent offense, I believe that they should be detained almost every single time instead of the revolving door that we currently have. I want to move to young offenders. The new prevalence of young offenders, especially in gang violence, in Toronto is very troubling. But there is no sentencing reform in Bill C-14 with respect to young offenders. You close a loophole clarifying what violence is for purposes of custody, but the bill still does not increase sentences. For second-degree murder, for instance, the Youth Justice Act limits custodial sentences to 4 years. So they often wait for 1 to 2 years, get 2 for 1 in pre-custody time, and then by the time they're sentenced to a year or no time at all. And then they come out and terrorize our community. Why doesn't Bill C-14 increase sentences on young offenders?
Look, thank you for the question, and I think that there are some questions that we need to study and identify the correct response for. It may be very appropriate to bring those questions to this committee for deep study. The process of engagement that we undertook identified certain reforms that disproportionately fell into the category of those which apply to adults. We weren't necessarily doing the same, hearing the same level of feedback when it came to youth criminal justice, though there are some elements that we touched in Bill C-14. One particular piece, actually subsequent to the development of C-14 that we did hear, was the need to ensure that we're targeting people who would recruit young people into crime. Mr. Fortin actually is one of the people who first raised this issue with me, and it is present in Bill C-16. So this committee will have an opportunity to consider that particular issue. But if the committee wants to advance further work on youth criminal justice, I would welcome a study that benefits from deep engagement and expertise of Canadians who spent their careers identifying solutions in this space.
Thank you, Minister. Thank you, Mr. Barber. Over to Ms. Dillon for 5 minutes.
Merci, Monsieur le Président. Merci, Monsieur le Ministre.
Thank you, Chair. Thank you, Minister. And thank you to your team for being here at the committee. I'll start with a question to be very clear and to state this clearly. Can you confirm that people found guilty of sexual assault are not eligible to home arrest? How does the criminal code limit their access to the crimes of this grave nature?
Oui, les crimes sexuels.
Sexual crimes are among the most hateful ones. It is essential to look at the gravity of the offense that is committed. When a sexual offense has been committed, it is not appropriate, in my view, for this person to just stay at home. The bill that we're talking about here changes the rules to ensure that it is no longer possible to only receive house arrest.
People who commit sexual crimes, which are posing, in my view, an epidemic across Canada of gender-based violence and sexual violence, need to be met with serious penalties, not only to separate that person from potential future victims, but also to send a strong message of deterrence and denunciation. If you commit sexual crimes in Canada, the Government of Canada does not believe that house arrest is an appropriate sentence.
Thank you, Minister. And comme que vous le savez, as you know, in Quebec already, there have been 5 femicides. We're just still in January, and since the beginning of 2026, we've had 5 femicides. Bill C-14 expands reverse onus for serious violent offenses, including, and there's nothing more tragic and sad and preventable than intimate partner violence. Can you clearly outline which offenses are captured by this expansion of Bill C-14?
OK. Juste avant de répondre en substance.
Before answering substantially to your question, it's important to state that every femicide is an unacceptable tragedy. We need to change the rules to protect women. When I saw the news that there was a fifth feminicide in Quebec this month, it's unacceptable. This bill will change rules around reverse onus.
Protect those who, to protect against sexual assaults where we know there is a predictive value that a further crime could be committed and sometimes a fatal crime could be committed. In addition to the measures that are included in C-14, there are massive changes in Bill C-16, the Protecting Victims Act, that target intimate partner violence and gender-based violence, including the creation of constructed first-degree murder charges where we would have cases of femicide, where the murder is carried in the context of a sexual offense, where the murder is carried out of a motivation for hatred towards someone, including because they are a woman, where a murder is carried out following a pattern of coercive and controlling behavior. There's a number of other measures included. I don't want to presume I should talk out the clock on your time here.
I think it's a very important topic, if you can.
Certainly. So in addition to the femicide charges, again, getting into a separate but related bill in my view, we also want to make changes to the criminal law that will potentially intervene before a relationship becomes violent and before violence becomes fatal. That's why establishing a standalone crime of coercive control is so important. When it comes to reverse onuses, to go back to your previous question, we also have measures that apply to human smuggling and human trafficking, which can often be intertwined with some of the issues that you raised. There's a lot of material to help address some of these challenges, but to the extent the committee identifies further ways that the criminal law can offer protection to women facing violence or that could prevent femicides going forward, know that I would welcome your feedback.
Thank you so much. And quickly, I think I have 30 seconds. We're talking about reverse onus. Can you please tell us how this bill would withstand charter scrutiny?
Yeah, certainly. So reverse onuses exist in Canada's criminal law already. We have not changed the law so every single charge suddenly the accused faces the burden. But there are certain charges that have become a significant social problem, sometimes because of the seriousness of the crime, sometimes because of the likelihood for recidivism, sometimes because they line the pockets of criminal organizations. When we're looking at reverse onuses, for example, for home invasion, and auto theft, when we're looking for reverse onuses tied to trafficking, when we're looking at reverse onuses that are tied to assaults that involve choking or strangulation, all of these have touch on some of those categories that I've established. We want to ensure that our policies do not fundamentally shift the burden in all cases, but are targeted towards certain crimes for particular reasons.
Thank you. Thank you, Ms. Dillon. Okay, Mr. Fortin, to you for 2.5 minutes.
Monsieur le ministre, j'ai 2 minutes et demie.
Minister, I only have 2.5 minutes, so please be as brief as possible. C-48 has a parliamentary review committee clause after 5 years. In a few seconds, could you tell me why there's no such clause in this bill?
Look, I'm confident that the rules that we put in here reflect the collective thinking of law enforcement and those who administer the justice system over many years. To the extent that this committee wishes there to be reviews, I'd be interested if that is actually the majority view of this committee.
You don't think it's useful or necessary?
C'est possible, mais
It's a possibility, but I really trust the process and the experts if they feel it's a good idea, but that's really up to the committee to make amendments. You talked about femicides. We're all worried. We want not only to end femicides, but violence in general. But that is an especially troubling problem when it comes to intimate partner violence. Do you believe, because the data I've seen is that these are often crimes that are committed as a crime of passion? I have doubts, but perhaps you could reassure me. Is people who commit this type of crime will actually change their behavior because you increase the lengths of sentences in line with the provisions of C-14? Or rather, is it more important to work on raising awareness, to work on education upstream to avoid that individuals who commit such heinous crimes don't commit them? Isn't on this rather that we should be working rather than on sentencing? In my view, it's important to work on both fronts.
We'll run out of time. To me, it's not just denunciation through longer sentences. It's also changes to the bail system when we have an underlying offense that has predictive value that may lead a person to commit a further violent and potentially fatal offense against someone going forward. So yes, denunciation and deterrence, I believe, can have an impact. Having better rules at bail can have an impact. But the long-term solution, to your point, will require investments in frontline organizations and upstream supports that will build healthier people who are not prone to violence over the course of their lives at the same time we change the criminal law.
Thank you, Mr. Fortin. I apologize if that's all your time. Mr. Lawton for 5 minutes.
Minister, we have seen the broken Liberal bail system tax police services tremendously because they spend so much time and energy having to, in some cases, uphold unenforceable bail conditions, go after the same small number of people over and over again. And this is part of why so many police services have come out in the last few weeks and said they want nothing to do with your government's gun confiscation scheme. Every single police service of jurisdiction in my riding, the St. Thomas Police Service, the Aylmer Police Service, the London Police Service, the Ontario Provincial Police have said that going after law-abiding gun owners is not a policing priority. Why is it a priority for your government?
Look, just very quickly, I think when we're dealing with a certain class of firearms that were not designed for a civilian application but were designed to kill people, I don't believe that those particular firearms belong on our streets. The first few days have seen now more than 20,000 firearms returned as part of this process, which is having a positive impact. But I do want to turn back to the priority of the day, which is the Bail and Sentencing Reform Act. We've had the opportunity, we've missed the opportunity for months, and I don't want to necessarily get into the argument as to who's responsible because we have different views on that. But we're here today, and we have an opportunity to pose questions about the motivation for the changes to the Bail and Sentencing Reform Act. When my colleague from Public Safety comes before the appropriate committee, I would suggest
I hope
the
you'll
questions
tell him
would
to
be
do
best
that
put
soon.
there.
The invitation's been outstanding for many months. But the reason it is important is because police are saying that your government is not aligned with what their core priorities are. So I'll ask it a different way. How many lives do you think will be saved by seizing firearms from lawful, vetted firearms owners in Canada?
I disagree with your characterizations that police are saying that their priorities are not aligned with the government's. Their priorities are embedded in the piece of legislation that is before this committee, which we're not talking about in this exchange right now. Police have asked us to make these particular changes. We're here to advance changes on bail and sentencing.
It is relevant, Minister, because police are saying that the people causing them the greatest grief are people that are out on bail because of your reforms. You have not acknowledged or accepted this committee's invitation to testify on your mandate and priorities in many months. So I have to ask you this now. Will you be accepting the Federal Court of Appeal decision that your government's use of the Emergencies Act was unconstitutional, or will you be appealing it?
As you're well aware, as legal counsel engaged on the file on behalf of the Government of Canada, when you've got a case that's recently been before the court still during the appeal period where the department is analyzing the content of the Federal Court of Appeal's decision, we're not at liberty to discuss the specifics of the file.
So you're not answering. I yield to Mr. Baber.
Attorney General, in Bill C-48, the government already tried the reverse onus strategy, but that still resulted in catch and release, even for offenses when bail was sought with a reverse onus. So wouldn't Canadians be right to be concerned that even though you're expanding the list of offenses to which reverse onus bail would apply, the result of this Bill C-14 would be the same as Bill C-48, which is a revolving door in our bail system?
My impression until this moment, based on statements that have made publicly by your colleagues, was that the Conservative Party of Canada has long supported the use of reverse onuses and to help improve the decisions in the bail system. I believe it has had a positive impact to some degree in Bill C-48, and that the changes proposed here will have a further positive impact. But in addition to the reverse onuses, we're also changing how bail is operated, not just by providing clearer direction on the principle of restraint, but also looking at the tertiary ground of bail, which is ensuring there is public confidence in the system by looking at not only the seriousness, but the number of offences that a person has put in place. But to just take a step back, even if we get bail reform perfect, we also need to make investments in the front line and upstream in communities to help reduce crime over time. There is no silver bullet.
If I may, Attorney General,
Certainly.
while the Conservatives certainly support expanding the list of reverse onus bail offences, that doesn't mean that bail should continue to be undermined with the principle of restraint or the latter principle, which this legislation fails on. But I'd like to take you further and talk about the fact that C-14 expands the list of reverse onus offenses. However, it doesn't clarify the burden of proof to be met in reverse onus offenses, and this leads to inconsistent applications by the courts. We've heard from multiple police forces asking the government to clarify the burden of proof to be applied on reverse onus hearings. Why doesn't Bill C-14 do that?
So it actually does. And there's two things that I'll just want to address that you mentioned. One, you spoke to the latter principle, which the bill makes clear does not apply in cases of reverse onuses. But on the substance of the issue that you've just mentioned, and this actually came directly from conversations from my Conservative counterpart in Ontario, Attorney General Doug Downey, who worked with us to say that we not only need to put the burden of proof on the accused in the reverse onus scenario, but specifically that they would be required to present credible information on which the court can conclude that they do not pose a public safety threat. That was the result of conversations to find the best path forward. I think it works. I think it's going to work well, and it's been included in the bill.
Thank you. That's all your time. Mr. Housefather, for 5 minutes.
Thank you very much, Mr. Chair, and thank you very much, Mr. Minister, for being here. Wanted to just clarify, you're here in your capacity as Minister of Justice to defend a bill that you're putting forward as Minister of Justice of Canada. Is that correct?
I sure hope so.
Yeah. Not Attorney General, because it's a different function that you also occupy. I wanted to also just mention, since it came up, and it seemed to be a universal claim, that the police in my riding, la police partout au Québec,
Police everywhere in Quebec has been participating in the effect to gather firearms. It's not all police services in the country that are against.
We were both elected in 2015, and, it sort of sounded to me a little bit like there was a claim that the principle of restraint and the latter principle somehow arrived in Canada with Bill C-75. These are both concepts long rooted in the common law tradition, correct, Minister?
Yeah, certainly, and specifically we could point to the Antic decision, for example. There's a slew of decisions that would discuss these principles at length long before Bill C-75 was introduced.
The C-75 wasn't even the first time they were codified. They were codified in the Bail Reform Act in the 1990s, correct?
I'd have to look at the date, but that's my understanding.
Yeah. So can you just sort of talk me through the idea of simply uprooting these principles and completely getting rid of them would probably be unconstitutional, would it not? I understand we are limiting, for example, the latter principle by saying that when there's a reverse onus, where where the applicant has to, has the onus of proof of why they should get bail, we're eliminating the latter principle. But you wouldn't be able to eliminate it for every single person seeking bail, right? Either of these concepts?
No, that's right. Well, look, the answer is yes. And I think the key point here is that what the government of Canada, or rather the Parliament, could choose to do is remove the language from the code. But to the point you made in your previous question, the principle remains as a result of common law decisions and would continue to be interpreted in a way without the guidance of Parliament. So the correct path, if we have a sense of how bail hearings should operate, how these principles should be applied, we should direct the courts with the language that we put into our laws rather than delete them from our laws, knowing the underlying principle remains to be interpreted in a different manner. Completely
in agreement with you. And you would say that community safety is one of the absolute focuses of your portfolio right now, right? Not only a focus of your portfolio, but a focus of the government, correct?
Absolutely. In one of the recent conversations I've had with the Prime Minister, he reiterated for me and others that protecting Canadians is the #1 job of the Government of Canada. This is a top priority, and it takes backseat to no other issue.
And he reiterated those comments yesterday at Holocaust Remembrance Day, where he talked about this being an absolute priority to protect our communities and keep them safe, which is part of a suite of measures that you brought forward, correct? You're not going to achieve every single thing in one bill. You actually have 3 bills before Parliament right now, 2 of them before the Justice Committee, 1 of them before the House, that all will contribute to public safety, correct?
Correct, and I would take it one step further to say that criminal law reform is one important tool we must get right, but in and of itself won't solve the problem unless we also support the people who enforce the laws, the people who administer the court system, and make the upstream investment to build healthier communities and people that will be less prone to criminal lifestyles over the course of generations.
And I think over time, this has been one of those issues where parliamentarians from all 3 recognized parties have been able to work together to implement bills that meet the needs of the times. And one of the needs of the times today is to keep Canadians safer and keep communities safe. This should be a nonpartisan exercise, in my view. You, Minister, have always shown your openness to accepting amendments from other parties and working together to try to craft the best possible bill. That would be the case for C-14 as well, correct?
Yeah, absolutely. We did the best job that I think we could in collecting the feedback from different actors in the justice system and putting them into this bill. If, by virtue of this committee's study into bail and sentencing previously, there are other ideas that you have, I know that we would consider them in good faith. My sense is if we can send a strong signal to Canadians that there is multi-partisan agreement on the path forward on bail reform and on sentencing reform, we would be doing collectively a great service to the country.
And thank you, Mr. Chair.
All right, thank you, Mr. Housefather. We're going to make sure we end at 5:30, Minister. So starting the 3rd round, I'm going to go 3 minutes, 3 minutes, and 2 minutes. So I'm going to go 3 minutes to Conservatives, 3 minutes to Liberals, and 2 minutes to Fortin. So, Ms. Kronos, I understand you're going for the Conservatives.
Thank you very much, Mr. Chair. And Minister, thank you so much for coming today. One of the things that I have observed in the back and forth between the folks that have been trying to make the the whole area of bail and sentencing better for Canadians is that there's been some real differences of philosophy. And one of the things you've done is you've brought back a number of offenses. There's an ongoing dialogue with the courts over a number of these things that are contained in the bill. And I'm wondering what you're going to do if the Supreme Court of Canada decides that any of the provisions of this bill are unconstitutional.
Well, we've taken great care in how we've drafted the bill to take the feedback from law enforcement, from actors in the justice system, apply our own assessment as to the constitutionality of the provisions, and I'm confident the measures we put forward are in fact constitutional. I don't want to go down the path of making assumptions that a bill I would put forward is unconstitutional. I swore an oath to protect the Constitution, so I won't accept the notion that we will need to deal with the unconstitutionality of the bill that Parliament's now addressing.
Well, that's wonderful in theory, but in practice, the reality is that it does happen, and there is an ongoing dialogue between the courts. So I'm going to ask you again what you would do if it turned out that some of these provisions were unconstitutional.
Look, I revere the courts in this country. Their role must benefit from independence, and to the extent that they have feedback on how we can promote public safety within the boundaries of the Constitution, I would accept it to the extent that it's the court. In fact, governments, in my view, do not have a reasonable option but to respect the independence of the courts. We all have to know what our role is if we're going to protect democracy in this country, and at a time when rule of law is threatened around the world, including in many countries that have seen an erosion of the liberal democracies that were built up over generations. I think it would be dangerous to project that we would consider seeking to oppose the ability of the court to do its job independent of political actors.
Well, thank you for that, Minister. I'm wondering if you think you could identify a category of offender who will now be detained that wouldn't have been detained under the existing law for C-14.
Look, one of the things that's really important is that we don't categorize offenders. Criminal law is uniquely individualistic, as is sentencing, as is bail hearings. It's really important to me that we maintain the ability of the court to dig into the facts of an individual case. I do think that there are classes of offences, for example, those that we've identified in the reverse onus provisions included in Bill C-14, where a person who's facing charges of those specific offences will be less likely to be released on bail. But categorizing offenders as groups of people, I think, would be a dangerous prediction to make.
Thank you. Okay, so we're going to move to Mr. Housefather, who's going to get 2 minutes, and then I'm going to give Mr. Fortin 3 minutes.
Oui. C'est un plaisir de donner une minute à mon ami.
I'm quite delighted to yield one of my minutes to Mr. Réal.
I'm going to say one thing, which is I think that this is a really important bill. I think it needs to move forward through this committee, go back to the House, go through the Senate, become law, and keep Canadians safer. Mr. Minister, you've had a lot of opportunity to answer some questions today. You had a statement. Is there anything left that you didn't get a chance to say that you'd like to say before we close your time on C-14?
Well, look, since you put it to me, there's one message I'd like to share that I haven't through my remarks. It's thank you. The number of people who've been willing to give many, many hours of their time to the development of this bill is extraordinary. I think about the national policing organizations, not just the Canadian Association of Police Chiefs or the National Police Federation or the Ontario Police Association. I think about Ryle Neal, the Chief of Police in New Glasgow, my hometown. I think about the small-town prosecutors and defense lawyers who've shared their experiences with me. I think about the mayors of big cities and small communities who fed into this process, and I think about my provincial counterparts in particular. I have never been involved with an exercise in consultation and engagement where people so willingly gave their time and energy to something that may not have been their legislative responsibility, but because they cared and wanted to have a positive impact on the country. This was cooperative federalism at its best, and to the extent that we can embed their recommendations into Canada's law, I think we'd be doing justice, no pun intended, to the very real feedback that they've shared based on their own life experience.
Thank you.
Thank you, Mr. Housefather. Mr. Fortin, you have 3 minutes.
Merci, Monsieur le Président.
Thank you, Chair. Minister, first of all, let me just say that I appreciate C-14, but I really encourage you to consult not only police services, but also the different bar associations, including in Quebec, and also the Association of Defense Attorneys. You might get a different view of this bill, which may actually impinge upon a lot of individual freedoms. I'd like to know who was consulted around on the impact of these release plans.
Okay, j'ai quelques conversations.
I had some conversations, including within my department. Sometimes it's me, sometimes it's it's the parliamentary secretary. With the Quebec Bar Association, I had conversations with defense attorneys. when I participated in such consultations, I didn't ask the question, there's not much time, I understand. It was just a general comment. So the question of release conditions.
Didn't show up and say, on this specific aspect of the bill, what's your feedback? I said, we're looking to reform bail and sentencing. Tell me how we can improve the system. So we got these different ideas from different parties, not because I was seeking feedback on each specific piece with each group, but more globally asking what priorities would inform the legislation.
Merci, Monsieur le Ministre. Plan de mise en liberté.
Thank you, Minister. On bail, does bail reform, the release conditions? Who put forward this idea? I'm not sure how to say it in English. Someone could perhaps help me. The bail regime. The first person that I consulted was the Attorney General of Ontario, Doug Downey, who suggested the idea initially. There are other people who looked at the idea. And what is the aim? Will it be useful? Will it be relevant? What undergirds this? It's a new concept.
Because I don't want to talk about the clock. The initial conversation started with proposals around changing the standard of proof that someone would need to make, but it would create many uncertainties. But we wanted to ensure courts would make a decision based on real information about whether someone poses a public safety threat. So that conversation evolved into a new idea that rather than changing the standard of proof, we would be able to provide reliable information to the court in order to allow the court to make an informed decision.
Merci, Monsieur le Ministre.
Thank you, Mr. Fortin.
J'apprécie.
Minister, thank you very much. We stop right at 5:30. We appreciate all the demands on your time, and we're grateful for you taking the opportunity to come and speak to this important piece of legislation. I'll suspend for a few minutes and get the next panel ready.
Okay, so we're just going to switch over to another committee for like the 5 minutes while they let Sean leave, and then we'll come back to it. We'll watch the final hour of justice, and that'll be it for today. Also, one other thing before I start the audio on this. I think it was Funny who mentioned it to me at the beginning. Question period is going to be at 11 a.m. tomorrow. They have Friday off, so question period's not at the normal 2 p.m. time. It'll be at 11 a.m., and there's no committees on tomorrow. Well, actually, there is. There's one at 3:30. I have a feeling that's going to get canceled because the House only sits till 2:30. I mean, I guess they could still do committee, but... yeah, I was just looking ahead for tomorrow. Basically, we've got question period, and that's looking like it. I'll see what's on this other committee, but here we go.
Just interested in your take, all of you, actually. We'll go next to Ms. Horlings. Drivers Inc. is obviously a focus of this study. It's an aspect of it, and a huge driver. But are the issues even deeper than Drivers Inc.? And I just want to kind of confirm that, just because when we're trying to establish what the priorities are and the problems are, obviously we're focused on Drivers Inc. But, things like I heard today with respect to the situation of the truck stops, the roadways, the lack of scales, actually play a fundamental role in safety. So is it a problem, granted, from your perspective, but there seems to be a lot of deeper issues here, right?
Sorry, you wanted me to start at this one?
Sure.
We only have time
yes.
for you, Ms. Horling, so I'll turn it over to you for 20 seconds, please.
Okay.
There is so many deep issues within the trucking industry that need to be addressed, including what Mr. Lundwick said in terms of insurance companies.
Yeah.
Everything needs, wherever there's a financial transaction that takes place within the industry, it needs to be reviewed. Simple as that.
Thank you, Ms. Horlings.
Thank you, Ms. Lawrence. Ms. Horlings, thank you very much, Mr. Kellaway. On behalf of the entire committee, I want to thank our three witnesses for being here today, sharing their experiences as owners and operators of trucking companies across the country. It's very helpful for our
Okay, so they're about to suspend this one. So all of them are on the break at the half hour or at the hour, and they're all switching to different witnesses. So what's going on in the House? Maybe we can watch that. Oh, Garnett's talking in the House. Yeah, we're going to watch this instead. Let's see what he's got to say.
Rights and defending Canadian citizens, and I wonder if my colleague has reflections on that.
The Honourable Member for Saint-Hyacinthe Bagot Acton. I closely listened to my speech's presentation, and I am in full agreement, but I didn't hear a specific question in his comment, so I'd like to thank him for his work. We work together in certain interparliamentary associations that work on, or rather against, human rights violations in China and on the influence of China when it comes to subverting foreign countries. And I'm looking forward to working with my colleague on the matter. Questions and comments? The Honourable Member for Shefford. Thank you, Mr. Speaker. I went to Washington in 2023 with a Uyghur delegation to meet Congress people and to talk about this bill. We talked about it earlier, but we go back to this example. It's striking. Do we need a bill with a lot more bite? In C-251, is it not normal to ask for a bit more bite when it comes to forced labour? Because this is a request from us, from lawmakers in the States. We want to work with them to see what a good practice would be in international trade, in agreements. So talking about human rights isn't bad, isn't taboo. The Americans have asked us to be more active on the matter so that we don't have any blood in our products. What does he think about that? The Honourable Member for Saint-Hyacinthe Bagot Acton. Well, it speaks for itself. We want a more stable geopolitical environment, and we have to fix our issues with the States. Now, if the model didn't work, I wouldn't say that we should copy it. But if the system works, then why should we not take inspiration from it? That's my point. Their system works. They have billions of dollars of products seized from one single region. For Canada, it's just one shipment. So it's apples and oranges. Our model here in Canada has failed.
The Honourable Member for Sherwood Park, Fort Saskatchewan.
Well, thank you, Speaker, and I'll be sharing my time. Today, the House is debating a trade deal between Canada and Indonesia, a deal that Conservatives support advancing to the next stage of consideration. In the context of this agreement, I would like to offer a few observations about the state of the world, which have bearing on how and with whom we make international agreements. Over the course of my time following international affairs, we've witnessed a dramatic shift in tone and expectations within certain parts of the democratic world. That shift has been from the unrealistic liberal optimism of the past to the exaggerated liberal pessimism of the present. In an earlier era, liberal optimism was evident in the attitudes and decisions of elite figures who proclaimed an inevitable march of history towards democracy, freedom, justice, and an international rules-based order. They thought it would happen, and they thought it would happen relatively easily. This optimism held, for instance, that engagement and increased trade with China and with other authoritarian countries would gradually, inevitably transform their governments into progressive democracies. It's easy to see why liberal optimism is no longer in vogue. It's no longer popular because it clearly failed. Authoritarian regimes that were once hiding their strength and biding their time are now confidently asserting the supposed superiority of their political model and even winning converts in the free world. And so, in some quarters, the transformation has been from this naive optimism to a new liberal pessimism, vividly on display in the Prime Minister's recent remarks at Davos. No longer is the triumph of freedom, democracy, justice, and an international rules-based order presented as history's inevitable endpoint. Instead, the idea of a free, open, and liberal international order is dismissed as a mirage, as an illusion akin to the lies once propagated by communist apparatchiks. The argument of the Prime Minister was this false equivalency, that both the authoritarian system and the liberal rules-based system are based on lies. The Prime Minister is not merely arguing that a rules-based order is difficult to achieve, under strain, or not guaranteed. Rather, he is arguing that the very idea of such an order is fundamentally, necessarily an illusion. Speaker, I do want to point out that both of these dispositions, yesterday's liberal optimism and today's liberal pessimism, both have ironically been used to justify the same policy agenda. The Liberal Party of Canada, at least since Pierre Trudeau, has always wanted to pivot away from a foreign policy of engagement primarily with democracies towards a foreign policy that seeks a kind of strategic balance between the United States and Communist China. They have always been interested in the idea of ever-deepening engagement with authoritarian powers, especially the CCP, though they have justified it in radically different ways. In the past, liberal optimism was used to justify engagement with authoritarian powers on the grounds that such engagement would speed us up towards the inevitable triumph of democracy. Today, liberal pessimism justifies the same engagement, but this time on the grounds that such engagement is necessary and pragmatic in a world where international rules were always a mirage anyways. How curious that leaders with a range of personal ties and economic interests linked to the PRC have always wanted the same policy outcome, regardless of the convenient justification. But regardless, Mr. Speaker, today I call on the House to reject both of these flawed dispositions, the extremes of liberal optimism and of liberal pessimism. Instead, I propose that we embrace...
Oh, I hate to interrupt him because he's cooking right now, but we are going to switch back to the Justice Committee.
I will turn now for the first round for 6 minutes, Ms. Cronus.
Thank you very much, Mr. Chair, and I want to thank the witnesses for coming today. It's always a real treat to have the depth of legal knowledge that we have when the group of you come to this committee. So I want to start by just framing the questions that I'm going to ask. So since Bill C-75, the principle of restraint really has become the dominant lens through which bail decisions are made. And while the criminal code has always permitted detention on public safety and confidence grounds, the statutory emphasis on restraint has really shifted judicial culture towards release as the default outcome over the last number of years, particularly in Crown onus cases. And I think what we see with C-14 is the government has admitted that that approach just really isn't working. But at the same time, while C-14 attempts to recalibrate the culture by stating that restraint doesn't require release, it leaves Section 493(1) intact and unaltered, which means that it still prioritizes from a legislative perspective, or appears to prioritize from a legislative perspective, release first and conditions second. And so given that judges already have clear authority under Section 515.10 to detain, and that this legal authority sort of already exists, I'm wondering if you could talk a little bit about what concrete changes we can expect to see in day-to-day bail outcomes in terms of what Canadians can expect from the bill.
Thank you for the question. So I think one of the changes that is fairly new in terms of the criminal code is that the bail provisions will make clear that the principle that release ought to be the starting point at bail won't actually apply in a reverse onus situation. So this proposal really has the objective of reinforcing the presumption of detention in reverse onus hearings and trying to give a bit more teeth to the reverse onus bail hearing. In addition, there's a proposal in Bill C-14 that would make clear that the latter principle doesn't apply to people in a reverse onus situation, and it will clarify the burden of the accused at the reverse onus hearing. So I think...
Ask a little bit about what the practical... You're still talking about the theory. I want to know what practical difference it is. I asked the minister what category of offender will now be detained that wouldn't have been detained under existing law. I want to know how this is actually going to change things. What will defense counsel have to do differently? Who will stay in jail that wouldn't be in jail now? Can you give us some concrete examples?
Sure. So no one can automatically be denied bail, and we can't guarantee that certain provisions are going to result in the detention of anyone, because judges will always have discretion at the bail stage of proceedings to be consistent with the Charter.
493.1 is still in place, and so it's still the basis of their decision making. Is that what is new? What is different? What is going to change?
The objective is to ensure that there's more scrutiny given to bail release plans, particularly for people who are in a reverse onus, and that stronger bail plans will have to go before the court in a reverse onus hearing before someone's released on bail.
So it's marginal?
I wouldn't say marginal, no.
Well, what makes it not? I mean, this is the bail plans are already supposed to be there. This is the job of counsel. I mean, it sounds like what you're saying is counsel will have to do a better job. What is going to be different?
I think the hope is that more scrutiny will be given to bail decisions and that more information will also be before the court. There are a number of amendments in the bill that will ensure that the court has more information. You have to remember that bail hearings often happen within 24 to 48 hours after someone's arrested, and so there is limited information. But I think what the code can do is it can draw courts' attention to certain risk factors that are important to consider.
With all due respect, hope not being a strategy, hope is not a strategy, which is what you started the last answer with. And we are in exigent situations, 24 to 48 hours. What new information is there? What is going to change? Like, I'm really genuinely interested in knowing what will be different other than more paperwork.
I'm not sure there'll be more paperwork. I think, as I said, there's going to be more pressure.
Stronger bail plan is presumably more paperwork. What is genuinely? What is other than signaling some hope and some hope that things are going to change? What new tools do judges have? What tools have been taken away in the context of the underlying provision not changing?
So there's also going to be an expansion of the grounds for detention, which is quite significant. The tertiary ground will be expanded so that courts are looking at outstanding charges and determining whether confidence in the administration of justice will be undermined. I think historically courts tend to focus on, they're looking at, is there a pattern of behavior? They're looking at, are there past convictions? But what we've heard and what the minister has heard also is that there are concerns that people are being released and then they're caught again and then they're back in the system. And so ensuring that courts are taking into account factors such as outstanding charges, I think the government thinks would make a difference in this bill. So expanding the tertiary ground is one way that this bill would do that.
Thank you. Ms. Latanzio, to you for 6 minutes.
Thank you, Mr. Chair, and thank you, officials, for being here this afternoon, ready and willing to answer all of our questions on this very important bill. So Canada's bail system is built on the principle of restraint, which is about how decisions are made and not about guaranteeing release. Can you explain how Bill C-14 is providing direction to the courts and police on how to apply the principle of restraint while making clear that detention remains an option for repeat and violent offenders?
Thank you for the question. So the Supreme Court has interpreted the Charter as requiring restraint at the bail stage, since bail is about imposing restrictions on people on the liberty of individuals who are still presumed innocent. The changes in this bill aim to provide clear direction to police and courts in applying the principle of restraint. For example, as I mentioned, the bill would specify that early release should not be favored over detention when someone's in a reverse onus situation. There would be further direction provided to police not to release an accused person under certain circumstances, including for public safety. So police, when they're deciding whether or not to release or detain someone, they need to look at whether there's a need to establish the identity of the accused, the need to secure or preserve evidence, the need to prevent reoffending, or the need to protect the safety and security of any witness. So the bill would direct police, and any of those circumstances apply, they will have to detain an accused person. A direction will also be provided to bail courts not to release accused persons who are a flight risk, who are a danger to public safety, or whose release would undermine the confidence in the administration of justice.
Thank you. Provinces have asked for tools that work in practice and not on paper. So what feedback did officials receive from provinces and justice partners during the development of C-14, and how is this reflected in the final draft of this bill?
Thank you for that question. I can start on a high-level way and just build on what the minister said earlier. For the last number of years, at an official's level, at a deputy minister's level, and at a minister's level, those responsible for the criminal justice system have been collaborating on ways to strengthen the bail regime and the operation of the bail system. So part of that includes strengthening the bail laws in the criminal code. Part of that includes ensuring that the bail laws that are in place are being implemented as intended and being operationalized as intended. Part of that also includes working together on getting more information, more data on bail to have a better picture on that. Same holds true for the sentencing parts of the bill. So we have been working collaboratively with PT officials to discuss ways to strengthen sentencing laws in the criminal code in a way that's responsive to pressing public safety concerns in Canada. Those are the different ways that we're engaging with the provinces. That collaboration will continue after Bill C-14. If C-14 receives royal assent, we will work to support the bill's implementation. So there is an ongoing, constant conversation with our partners.
Thank you. On the subject now of the charter, so can you explain how the bill was designed to withstand charter scrutiny and avoid the kinds of constitutional problems that have led to bail provisions being struck down in the past?
Sure. Thanks for that question. You will know that in the work that we do as officials in the Department of Justice in supporting the minister and the government in the development of criminal law reform, that we will work very closely with colleagues in the department who have expertise in the charter, on the charter. We obviously look at case law. We look at constitutional decisions. That informs the policy and legal advice that we provide to the minister. The minister talked about his obligations under the Department of Justice Act that are twofold. Under Section 4.1, he has an obligation to table a report in Parliament where he believes that a piece of legislation is inconsistent. He has not done that. And as he said in his testimony, he does believe that the legislation is constitutional. We also have the Charter Statement, which talks about how the proposed changes in a piece of legislation intersect with charter rights and the kinds of considerations that inform the overall assessment around the constitutionality of the legislation.
Thank you. And one concern that has been often raised is the uneven application of bail laws across the country and across jurisdictions. How does Bill C-14 promote greater consistency in how bail is applied by the courts all across Canada?
Thank you. So I could give two examples of this. So we've heard concerns that the principle of restraint is not being applied consistently across Canada. There were concerns that people were being released even though they were posed a risk to public safety, for example, under the secondary ground of detention. So Bill C-14 would give more direction to courts on how to apply the principle of restraint and ensure that it's being implemented as intended consistently across Canada. We've also heard that the reverse onus regime is not meaningfully being applied in practice, that it doesn't have enough teeth. So Bill C-14 has a number of proposals, as I mentioned earlier, that would reinforce the presumption of reverse onus cases and improve screening in these cases across the country.
Thank you, Ms. Latanzio. Mr. Fortin, to you, sir, for 6 minutes.
Merci, Monsieur.
Thank you, Chair. Thank you for being here. Just earlier, I raised the question of the Minister of the release plan, which is a new concept, and I was just wondering where that came from. My suspicion is that the release plan is an idea that strives to better involve the accused in their bail, and it might be valid in that sense, but I'd like to hear you on this. Where did this idea... I'm not saying it's a bad idea, but I'd just like to hear where it comes from to ask the accused, because of 515 from the criminal code, we have to hold you unless you have a release plan. Where does this idea come from? Please say a few words on this. Thank you for the question. Each time an accused is at the court for an offense at the bail stage, the question is, can the accused be released in a safe way? And so what is the plan being presented to court to ensure that the accused does not pose a risk to public safety or a flight risk? It's a practice that already exists at the bail hearing stage. When it comes to reverse onus, it's not clear what is requested of the accused at this stage. And as we were saying earlier, we heard many concerns from provinces and territories that strengthening reverse onus was not robust enough, that not enough is being demanded of the accused to release them. And so Bill C-14 says it's absolutely imperative that the accused demonstrate to the court that the risk does not exist. So it's not only about reverse onus. The judge should say, "Madam or Sir, can you prove to me that you will be here for your next appearance, and that or that you will not repeat offend?" But more, it goes beyond this. So if I fully understand the concept, it's not only that the accused has this onus, but they must demonstrate that themselves. They have to be proactive in a way. Dear judge, this is what I propose: that I'm not a danger to the public, that I won't, that I don't pose a flight risk, and so forth. So do you confirm that I'm right when I say this? Do you have an idea of what should be included in this release plan? Answer: it really depends on each case, each situation. For each case, there's a different risk depending on the offense. Is the accused someone who lives with their parents, for example? Are there people available to supervise the accused? Do you have to take the telephone away, the accused telephone away from them? What measures are necessary to mitigate risk? Does this concept exist? This idea of requesting a release plan, does this exist anywhere in Canada in any given province? It's a practice in bail hearings. This practice exists everywhere in Canada. So the accused has to submit a plan to demonstrate to the court that they will be supervised. And does it work? Is the belief that there's less recidivism when the accused is proactive in this way, submitting a plan? That depends on the plan. But the idea is yes, that if there is a discussion about a plan, a discussion that's more targeted to mitigate specific risks with that specific accused person. I was talking about this with the minister earlier. The statistics on recidivism and rehabilitation. Do you have something on this? Is this coming? Do you have an idea of what can be done with that question? Data collection. We know that currently 3/4 of inmates in prisons are they're waiting for their trial. Is the time spent in detention help them to be rehabilitated if they are in fact convicted of their crime? Do you have any statistics on this, or what are the plans? Just a second, please. Unfortunately, there are no national data currently available provinces and territories have the responsibility to collect this data, but there are many provinces and territories who do not submit the data. And what about in our federal penitentiaries? Yes, we do have stats on on federal penitentiaries. For those who are accused of a bail breach, it's really the provinces and territories who have that information about bail breaches, for example.
Favor for 5 minutes, please.
Thank you. I want to go back to Ms. Moore and follow up on the line of questioning by my friend Ms. Cronus. So you've already tried this in Bill C-48. You have created a various reverse onus offenses, and what you seem to be doing in Bill C-14 is expanding the list of reverse onus offenses where the accused has to prove that it's up to them to get bail as opposed to for the Crown to prove it. You may try to restrain the principle of restraint, which directs judges to put mind to the earliest release possible. But nothing's being done about the latter principle, which is basically directs the court to consider the least onerous circumstances and the earliest circumstances under which an accused would be granted bail. So what, in effect, are we doing here then?
So the latter principle is actually about the financial conditions that attach to an accused when they're released on bail, and it provides that the Crown has to justify every time you go up the rung of the ladder, the top of the ladder is cash bail. The Crown needs to justify why you're doing that. This bill would actually provide an exception to the latter principle to say that reverse onus provisions, the latter principle doesn't apply to reverse onus provisions.
The challenge is, especially when it comes to cash bails, Crowns are very hesitant to insist on serious cash bails, especially with folks without means. We also know that with sureties, this is often a problem. In fact, there was some discussion about the fact that we need to reevaluate the way that sureties are able to place a bond as opposed to actually place hard cash. This is something that is also absent from this legislation. I think Ms. Cronus is correct in saying that not much is going to change, and we're still going to be back here again and again until we decide that the latter principle is going to be repealed. And that is something that every police association in the country is calling for. Why is the Liberal government failing to repeal the principle of restraint and the latter principle?
Thank you for the question. So just to be clear, there is a provision in the bill that would impact on sureties. It's an escheatment provision which ensures that all the information that sureties provide about their financial assets will go to the court to ensure that those assets can be taken if an accused breaches and they start an escheatment process. So I just wanted to clarify that. In terms of repealing the principle of restraint,
you have to disclose the assets. It doesn't mean that those assets are going to be taken. It's not as if you're placing them as collateral. So I have to correct you there, Ms. Moore.
yes. So the goal is that it will be easier to take assets if they know where those assets are, and that was an ask from provinces and territories to help.
That never happens.
The escheatment process.
That never happens, regretfully. Sureties are never actually prosecuted. This would be a quasi-civil proceeding where you try to seize on assets of a surety. I think there was an astonishing stat to the effect that in the province of Ontario, in the last couple of years, it has not happened once.
So we certainly are seized of the issue with the provinces and territories, and it's something that we are looking into right now. Every province operates differently in terms of escheatment, and so it really is something that we need to engage all provinces and territories on to come up with a solution for the criminal code.
Ms. Moore, there was some conversation in this committee about the fact that a sentence, a custodial sentence, doesn't actually mean the time period that the custodial sentence implies. For instance, in the last couple of years, it is more prevalent to see courts giving 2-1 or 3-1 for pre-custody trial time, especially if conditions in prison are not good. So as provinces are dropping the ball, we're seeing, by virtue of our sentencing scheme, that pre-trial custody time eats significantly into custody time imposed by the court. I wonder why the legislation is silent on that.
I'll turn to my colleague Joanna Wells to answer this question. Thank you.
Thank you for the question. I believe you're referring to credit for pre-sentence custody for offenders who are held pre-trial. So this comes down to the principle of parity in sentencing, which holds that individuals who are similarly situated, who commit similar offenses in similar circumstances, should be treated the same or as similarly as possible. And so courts are permitted to take into account the time they spend in prison before their trial and sentenced, so that the ultimate time behind bars comes out to be about the same. The criminal code provides for a 1.5 to 1 ratio.
Thank you, Mr. Baber. That's all your time. Mr. Chang, over to you for 5 minutes.
Okay, so like I was just saying in chat, we'll call it here with that. And I did mention before, we have question period early tomorrow at 11 a.m. I don't imagine it's going to be too busy. There might not be too many people even there at all, because it's going to be like almost a Friday type vibe. There's a lot of conventions on this weekend. There's the Liberal convention. There's the Conservative convention. So we'll take a look out for that. I'll try and get some clips on from that. What time is QP tomorrow? 11 a.m. Eastern Standard Time. So 3 hours earlier than it usually is. And yeah, there's also, I don't usually like to promote other channels, but just for, if you guys want some political fix over the weekend, there is a really good event being live streamed with like all the top conservative content creators. There's the, oh yeah, Pierre's leadership review. Yeah, there's that, and then there's the convention. So we'll get, what's going to happen there is you're basically going to see Pierre come out and re-announce his leadership and all that. So, but like, as I was saying before, there's a really good conservative like party going on after the convention, with like Jasmine Liane and Pleb Reporter and all those guys, Mark Nixon, Marco, I can't remember what his name is, but that'll be on like everybody's channel. Like, I'm not going to stream that, but if you guys want to watch it, I think it's on Saturday. It's either Saturday or Sunday, but yeah, that'll be live streamed on like Pleb's channel and all that. So it's nice to see some conservatives coming together. I might actually tune into one of their channels and watch it, but anyway, we'll leave it there for now. I'll let you guys go. Everybody have a good rest of your day, and I'll see you guys tomorrow. Thanks, everyone, for tuning in and watching. And then, Megan, thank you so much for gifting 5, and A Green, thank you so much for the super chat. Okay, now I'm going to go.